Hello, and welcome to Law Talk. My name is John Celebrezzi, and I'm the co-founder of the Celebrezzi-Zangi Community Legal Education Project, as we call it, CZ-CLEP for short. Our organization provides continuing education about the judiciary and legislature to attorneys, judges, government officials, and the general public. As a career educator, I recognize early on how important legal matters are and how they impact our lives. I am the nephew of the late Anthony J. Celebrezzi, who was the popular 5-term mayor of Cleveland and a member of President Kennedy's cabinets. As a tribute to his lifetime commitment to the legal process, we dedicate this show.
John's guest today is attorney Michael Ash. Michael graduated from Cloverleaf High and then joined the United States Air Force, where he was eventually selected to join the Air Force Honor Guard in Washington, D.C. Michael completed his undergraduate degree at the University of Akron and continued his military service in the Ohio National Guard as a member of the 179th Airlift Wing in Mansfield. Michael completed his JD MBA program at the University of Akron and was admitted to practicing law in Ohio and Federal District Court for the Northern District of Ohio in 2005. Michael resides in Medina with his wife and their children.
Mike, welcome to Law Talk.
Thanks, John. Thanks for having me.
Well, thank you for being here. Mike, today we're going to, I think, talk about a topic that's kind of near and dear to your heart, and that's criminal defense, right?
Yes, it is.
And you've been a criminal defense lawyer for how long now?
6 years.
6 years. You know, Mike, the first time I think I ever saw you, let's say saw you in action, you were in a trial in Medina County.
Yeah.
For a guy practicing 6 years, I've come to find out you're quite the trial lawyer, aren't you? You've tried a lot of cases.
I have, John. Just Monday I had my 4th felony trial for this year. It was my 22nd felony trial in my career, and I've had about 50 trials in total.
Thanks. Okay. We'll start with some really basic stuff, Mike, but explain to our viewers the difference between a felony and a misdemeanor.
Well, John, they're set by the statute, and our legislature determines what cases or what charges are going to be felonies and what are misdemeanors. Basically, a felony is a major criminal act. When you think of murder or robbery, those types of actions are felonies.
Okay.
And those are punishable by time in prison, a state prison. Misdemeanors are lower level offenses. Could be a simple assault or could be driving while intoxicated. And those have maximum penalties of local incarceration, and it's less than a year in the county jail.
That's the county jail when you talk about local incarceration. When somebody goes to prison, you're sent off to Chillicothe or some faraway place.
Right, Lorain, Mansfield.
Serious stuff. That trial I saw you in recently, that was a felony trial then?
Yes, that was.
So, I mean, there was the real deal.
Yes.
I see. Well, Mike, we've had many of our local judges on our show, and municipal court judges, common pleas court judges. So maybe can you clarify for my viewers or our viewers who has the jurisdiction over a felony as opposed to a misdemeanor?
Well, a felony is always going to be in the county common pleas court.
I see.
And in our county, Medina County, Judges Kimbler and Collier are the 2 general division common pleas judges. Okay. So they're going to hear all felonies. The 2 municipal court judges are Judge Chase in Medina and Judge McIlvaine in Wadsworth.
I see.
And they're going to have jurisdictions over misdemeanors depending on where it occurs. It's all within the county, but if it were to happen in Brunswick or Medina, it would be up with Judge Chase. If it was in Wadsworth or Lodi or Westfield Center, that would be in Judge McIlvaine's court here in Wadsworth.
But the penalty, the difference is the penalty. I mean, a felony, somebody could actually be incarcerated for life or even face death, correct?
They could, yes.
Where a misdemeanor, the max is going to be how long in local incarceration?
It's going to be less than 1 year.
Less than a year.
I can't think of any offense that gives more than 180 days for that single offense.
I see. Pretty common for 6 months. Okay, so misdemeanors, the domain of our municipal court judges, both of which have been on the show, Judge Chase and Judge McIlvaine. Felonies, again, both have been on the show, Judge Collier and Judge Kimbler.
Yes.
Is it possible, Mike, for a common pleas judge to deal with a misdemeanor offense?
Yeah, John, it happens a lot. If someone were charged with a low-level felony offense,
Yeah.
and the facts supported a plea agreement where the state would reduce the charge from a felony to a misdemeanor in exchange for the defendant's plea
Okay.
to that lowered charge.
So you don't have to literally physically throw it back to the municipal court?
No, Judge Collier and Judge Kimbler both have authority to deal with misdemeanors, but it doesn't work the other way
Okay,
around.
so Chase and McIlvaine can't do felonies,
No.
but Collier and Kimbler can do both.
Yes, that's
Okay,
true.
all right, good explanation. The crimes fall under differing degrees, and it gets a little confusing sometimes.
Sure.
Those of us in the profession hear it every day, and I'm sure with the number of trials that you've done, you hear it a lot more than some lawyers. But what is the most significant felony crime? I mean, the granddaddy, the worst one can happen.
They say death is different, so I guess you would say that the granddaddy would be a capital case.
Okay. Capital meaning?
Capital punishment is a possibility, meaning execution.
Okay, so our defendant, if found guilty, if convicted,
Yes.
albeit by a jury of his peers or just a bench trial, and it's possible he could be executed.
Yes.
Is it true, Mike, that not every lawyer could represent a defendant in that type of a case?
That's almost true. If someone were to hire a brand new attorney to do a capital defense, they can do that. But when we talk about the court appointing someone to represent someone in a capital case, there are very strict guidelines that...
I imagine they'd be looking for somebody who has some experience here. Somebody's life is in somebody else's hands.
Right. The Ohio Rules of Superintendents, Rule 20, requires that an attorney have a certain number of years of experience, have a certain number of trial experience.
I see.
And they have to take a continuing legal education and become certified. They have to file an application, become certified.
When you say file at the Ohio Supreme Court?
Yes.
Okay.
And they can become certified to be appointed for indigent
Are
defense.
you? I mean, I'm curious. I mean, it's sort of a personal, professional question. Are you personally qualified to do this?
I'm not yet. I do have the number of years, I do have the number of trials, and I've done the continuing education. But with this trial this week, I have not yet submitted my paperwork.
So you're telling me you're right on the bubble. You're ready to go. I mean,
I am. I'll hopefully be submitting the paperwork next week, and I'm not sure how long it takes for approval, but I otherwise meet all of the
but
requirements.
not all murder cases are capital cases, correct?
No, that's correct.
So what's the difference? I mean, it's the punishment, right?
Well, there are aggravating factors that make it a capital case.
Like what?
If in the commission of the offense there was a sexual motivation,
Okay.
If the victim was a child, if you're committing another felony such as robbing someone,
Okay.
that could aggravate it to where you could be facing execution.
So the idea of what you see in the movies, that the only way you could face the death penalty is premeditated. You've thought this all out and you've planned it. That's not necessarily always true then.
Well, premeditation is one of the elements on any murder case.
Okay.
But to get to that next level of
Capital.
talking about capital punishment, there has to be an aggravating factor.
Well, we've got to talk about some more basic stuff, but just before we leave capital,
Sure.
when that is, I mean, this is the stuff that you see in the media and you hear on the television,
Sure.
or see on television, whatever. But Mike, it appears that when somebody finally is convicted in a capital case,
Yes.
that it's a long, long time until unfortunately, they are executed. Why does it take so long?
Well, John, when we talk about capital punishment, what we're talking about is the people are giving to the government the authority to end someone's life.
Yeah.
And our Constitution has a lot of checks and balances on government power built into it.
Sure.
So what has developed is this theory that if we're going to take someone's life away from them, they are going to be entitled to certain appellate rights.
Okay.
And for a while there was a stay on execution, and not every state has execution. So it does take a long time. It is very, very expensive for the state.
When you hear on the news that it gets down to the governor's last word on it,
yes,
that's about it, right?
Yeah. If all of your appeals have been exhausted, your only chance is for clemency from the governor.
I see.
And if the governor does not sign that paper.
Sure. Well, we've been hearing, I mean, maybe because I knew you were coming on the show, but I mean, it seems like most recently we've heard a lot of reports about, folks that are heading for execution. So, I mean, it really does happen. I mean, it may take a while, but...
It really does.
Yeah. Well, let's shift gears maybe to a little lighter topic.
Sure.
What does it mean, Mike, to be indicted by a grand jury?
Well, again, going back to the power of the government comes from the people, and when this country was founded, they didn't like the idea of the government being able just to charge someone without any type of proof.
Okay.
So before an individual can be charged with a crime, the government takes its case generally to a grand jury. And the function of the grand jury is to listen to the evidence, to the government's side of the case,
Okay.
to see if there's enough there to charge someone.
Just charge. I mean,
just charge them.
That doesn't mean the guy's guilty of anything.
No, it does not. And not all cases that are brought to the grand jury result in an indictment.
But it's the way you explain it and the way I've seen it work. It's sort of one-sided, though, isn't it?
It's very one-sided. Generally, the defendant or the accused does not even know that the grand jury is talking about his or her case. They're not present to give their side of the story.
So they don't have a lawyer at this point in time anyway. They have no defense attorney.
No.
So it's the prosecutor talking to this group of people?
Yes.
And basically he's trying to make a point that we have enough evidence to charge this guy.
Yes, he's seeking their permission to charge an individual.
When we talked about juries with Judge Kimbler here recently, but so when you get called for jury duty, you could be the 12 people that I saw you talking to the other day, where you were attempting to convince them.
Right.
Or it could be this larger group of people that meets in the basement of the courthouse that's not quite as glitzy, but the prosecutors in there are trying to, I guess, get a majority of them to say there's enough evidence to move with this thing.
Right.
When they finish, they call this an indictment, right?
Right.
True bill?
The jury issues a true bill, and then there's an indictment.
Okay, then somebody's going to get arrested.
Someone's going to get arrested generally. There are times where they can serve the indictment on the person, and they are not arrested. They just show up for court at an arraignment.
Well, that brings me to my next question. You just said the magic word. After a person is indicted, he or she must appear before a judge for an arraignment. What's that mean? What does arraignment mean?
Well, we'll step back to the grand jury.
Okay.
They've issued a true bill, there's an indictment, and because it's secret, the accused does not know that he is being charged.
Okay.
Now, once he's served with the indictment, he goes to court for an arraignment, and the judge formally notifies him or her that they're being charged. You're notified of what the charges are, and you enter a plea of not guilty or guilty, depending on what you and your counsel decide. Usually bond is set at that arraignment, and that gets the case going, that initiates the case.
So, well, we're going to visit it just a little more. But there's another term in there I want you to explain to our viewers. I want to go back to arraignment for a minute, but
Sure.
Because that seems to be, that's where you have your first opportunity to tell the judge, I did it or I didn't do it, you're guilty or not guilty, and along comes your attorney, either court appointed or you hire somebody.
Yes.
But there's another term in there that I think it's confusing. It's called a preliminary hearing.
Okay.
Isn't that, I guess frankly, I thought it was the same as an arraignment, but I guess it's not.
No, in fact, all of the preliminary hearings that I've been involved in were at a municipal court level. And how the grand jury functions to see if there's enough to charge someone, that's sort of the judge's position in municipal court to see if there's probable cause to charge someone with a crime.
I see.
And there's a two-pronged test the judge looks at. One, is there probable cause to believe that an offense occurred? And then, if there is there probable cause to believe that this person who's being accused is the person that did it? So they're not making a finding of guilt or innocence. Like the grand jury, they're just making a finding of whether there's probable cause to charge them.
But the reason maybe that sort of makes sense, this pretty much is the purview of the municipal courts?
Generally. Now, sometimes during the hearing, it could be for a felony level offense. And if the judge finds that there's probable cause, they can bind over, it's bound over to the common pleas court, because the municipal court no longer has jurisdiction if it's a felony level offense.
Does that guy have to go, that person who's unfortunately bound over by the municipal court, is he heading to is his case heading to grand jury, or is he moving right to arraignment?
He could move right to arraignment.
Okay.
Sometimes what will happen is there'll be a municipal court preliminary hearing scheduled, but at the same time the prosecutor's office will take it to the grand jury.
I see.
Which will cancel the preliminary hearing, and then we'll just go with what the grand jury says.
And all this has to do with speedy trial guaranteed us by the Constitution to keep this thing moving along.
Well, the speedy trial is going to come into play once they're charged, once
Okay.
they're indicted
All
and
right.
bound over.
But my point is, they just won't leave you in a jail waiting forever. I mean, even if
Right.
it's a municipal court, you're going to have a chance to see the judge,
Right, correct.
try to make your case that
Right.
there's not enough probable cause. Okay, that's interesting. Okay, that's a good job. Thanks. Often wondered about that. What does the criminal defense attorney? I guess maybe a better way of saying this. When do you come in? When does Mike Ash arrive in the life of the criminal proceeding? What stage?
Sometimes someone might know ahead of time that
Okay.
there are going to be criminal charges coming. So they may wish to speak with an attorney before they're even charged.
Okay.
So they can go talk to the attorney, and then they'll get notice of the preliminary hearing, or if it goes to the grand jury, they'll just get their indictment.
Okay.
More often than not, the attorney steps in after the person has been formally charged, either when there's a preliminary hearing in municipal court or at the arraignment. Because at the arraignment, that's also where the
Sure.
court would appoint an attorney if someone couldn't
Yeah,
afford
we're
one.
going to get to that if you can't afford it. Okay, so assuming somebody didn't get arrested, but they received a summons and they were told to appear in court on date certain, and that's when the defendant is going to face the judge and say guilty, or he has the option, I guess, of saying,
Sure.
well, he could plead guilty or not guilty. Probably the more appropriate at that point in time would be not guilty.
Right.
Okay, so if you were retained counsel, you would just be right along with him, standing next to him when that happened.
Yes.
If he can't, you touched on it. But what if he just doesn't have the money, Mike? I mean, what happens then?
Well, hopefully everyone remembers from civics, both the Ohio Constitution and the federal Constitution guarantee you the right to have assistance of counsel in your defense in a criminal case.
So even if a defendant, wanted to hire an attorney of his own later on, I mean, this could be a little confusing for people. He knows he has to go to court. He's standing in front of a judge.
Mm-hmm.
And we'll just assume he doesn't have the money at that point in time. You're saying the judge will appoint an attorney to come stand right next to him then?
It's almost that simple. The one step that's before that, the person has to fill out generally what's called an affidavit of indigency and a financial disclosure form, and they have to qualify. They have to be indigent.
Okay.
if someone just says, well, I can't afford an attorney,
That's not quite enough.
right, we have to give the court some proof of that.
But when a person fills that thing out, that affidavit, and the judge then asks you, is what you put on this document truth, is probably a real smart thing to answer affirmatively, and it is in fact the truth, right?
Yeah, I don't think it's a good idea to ever lie to the judge.
Problem. Okay, well, that's important that people know that, though,
Oh, yeah.
because I think the concept is that anybody could get an attorney for any reason. That's not
Right.
necessarily true.
No,
you
that's-
have to qualify.
Yes.
But you are, in fact, as you said, as we all learned in civics, you are entitled to an attorney. And in this courtroom proceeding, that's why I've been in courts many times, and well, you spend more time there than I do. But that's why there's always the jury box pretty well filled with attorneys that can step in when the judge calls on one of them, right?
Right.
Okay. All right. Well, Mike, in a criminal case, what does the word discovery mean?
Before the charges come about, generally there are things like a complaint made by a citizen.
Sure.
You know, someone robbed me. So
Okay.
someone makes a complaint to a police officer. Police officer does an investigation. They write a report. They might talk to some witnesses.
Yeah.
Well, all of those things are going to be what the state is going to use in the prosecution of that case. That is discovery. That's the discoverable material. And
Well,
the defense is entitled
So
to,
you, as a defense attorney, you could actually demand that, or?
yes, if you don't, I think it would be malpractice.
Oh, okay. So with all this stuff, police reports, I guess the names of witnesses,
Right.
photographs.
Forensic evidence. In a drug case, you're going to get lab results, you know,
Okay.
that it tested positive that it was the drug. You might have fingerprint analysis or
So
shoe
there's
print.
nothing left to surprise here. I mean, you're fully aware when and if you get to trial, what the state has on your client, correct? I mean,
Yeah. It's there's very, very little that you wouldn't know. And most prosecutors' offices are very, very good at giving you what you're entitled to.
I see.
It helps facilitate the case if a defense attorney is able to show his client, this is the state's case, and this piece of evidence will prove this element, and you can walk through all the elements of a case, and the client understands
Yeah, you
that,
evaluate it then.
right. Then the client can turn around and say, okay, I think I need to, work out a deal, or, they have holes in their case, and we
Okay.
need to look at it that way.
So, I guess we'll just assume everybody knows what a trial is. I read John Grisham books and whatnot, but there's also something there that is not a word that's thrown around the dinner table. It's called a pretrial.
Yeah.
What's that?
A pretrial, after the arraignment, the defense counsel requests discovery, and so does the state. And the
Okay.
defense attorney has to give the state whatever discovery it has.
All right.
After each side has, a period of time to look at each other's discovery and maybe talk to some of the witnesses, the prosecutor and the defense attorney, sometimes the judge, has an off-the-record meeting. It's not a secret meeting, but it's not in the courtroom.
Okay,
There's no court reporter.
stenographer.
And they just talk about the case, and they talk about the discovery, and both sides have had time to evaluate
Sure.
the case. And that's where you start talking about a plea agreement, and maybe a plea agreement is reached, and maybe one is not.
Okay, back up just a little bit. I guess the assumption in the way you answered the question makes sense. You could demand everything. You are now representing a client. You could demand from the prosecutor's office, I want to see everything that you guys have on my client. They'll give it to you.
Yes.
But you said earlier, though, proof that evidence you would use at the trial,
Yes.
you got to give it back to them?
Oh, absolutely. Yeah. The whole idea of our criminal justice system sort of lies on the fact that we're not going to have trials by surprise.
Okay. All right. So it's a two-way street. I mean,
It is a two-way street.
Okay. But in the end, though, the burden of proof, the guy that's got to prove this beyond a reasonable doubt in a criminal case, is the prosecutor.
The prosecutor has the burden of proof beyond a reasonable doubt for every element of every
Okay.
crime charged. The only time a defendant will have a burden of proof is if he or she raises an affirmative defense,
Okay.
sort of not guilty by reason of insanity
sure.
or alibi,
Yeah, sure.
self-defense,
Okay. All right.
then there's a burden that shifts to the defendant.
At these pretrials, then, I can't think of a better, it's not, I don't mean to be sarcastic, but it's like make a deal. I mean, is that what is that a fair portrayal of what happens at a pretrial?
Yeah, it's a fair portrayal. You know, the state has a chance to fully evaluate its case. And maybe to back up just one little bit, once the defense gets the discovery material, there might be suppression issues that come up.
Sure.
And a suppression issue is where the state of Ohio has obtained evidence in an illegal way, a way that violates someone's constitutional rights,
sure.
Specifically the Fourth Amendment.
Fourth Amendment, right to search.
Right. So if that were the case, you know, the defense attorney would file his motion to suppress.
He's going to get a chance to argue that in front of a judge?
He will get a chance to argue that in front of a judge.
Judge going to make the last call here?
Judge will make the last call.
So albeit you got this packet of material and there was a disc of a video, you seem to think it wasn't, as a defense attorney, it wasn't obtained properly. If you can convince the judge that it wasn't, that's out.
That's out.
At that point in time, maybe the prosecutor is kind of interested in talking about a deal with you.
Right. But, you know, a lot of times the police officers do their job and the prosecutors do their job, and when you get the discovery and you talk with your client, it's in the client's best interest to work out some type of deal with the state. You know.
Actually, as a, you know, we talked about your frequency of trials, but that does make you, I don't want to say unusual, but it does in a bit. The fact you've had as many trials as you've had, for the most part, criminal cases do settle out at pretrial. Is that correct?
Most of the time.
Like
yes.
what percentage?
I don't know the percentage off the top of my head, but if someone told me that 90% of the time,
okay.
I would believe that.
Okay. Well, we're coming to the end, Mike. This is very interesting. Boy, we can go on all day. Tell the folks about your most memorable criminal case and the 6 years you've been practicing law.
Probably the most, you know, every case, and I assume you mean trials.
Yeah, yeah.
Every trial, every case, there's something that stands out about it. But probably in general, the most memorable trial would be my first murder trial. And in that case, there was an arson involved.
Yeah.
So not only did we have to deal with the normal criminal issues such as eyewitness identifications and cause and manner of death, but we also had to deal with, because it was an arson, we had to deal with accelerants and burn patterns and chemical composition of a certain accelerant. One of our defenses was that our client, the accused, was at home on his computer at the same exact time that the fire was being committed.
Yeah.
So we had forensic computer analysis.
Complicated case.
Yeah, and you know, there are just a lot of very interesting issues. Ultimately, he was convicted and he was given a sentence of 15 years to life. It was not a capital case, but I learned a lot from that case.
Yeah, sounds like it. Well, Mike, we thank you for being with us today on Law Talk. I imagine in your life, no one day is the same. It's pretty interesting business, isn't it?
It is.
So, okay.
Thank you, John.
You're welcome.
Comments made by John's guest on Law Talk are solely those of his guest and do not necessarily reflect the views of Celebrezze Zangy Community Legal Education Project. To view this show and others, go to www.czclep.org. In the Wadsworth area, a complete listing of dates and times of this broadcast, tune in to WCTV Channel 15 or log on to wadsworthcity.com and follow the links to WCTV.
At CZ-CLEP, we're devoted to the education of today's legal issues. Fueled by the public's keen interest in our legal system and current events, CZ-CLEP is dedicated to the educational venues aimed at enhancing the understanding by all citizens, regardless of age, education, occupation, or wealth.
A function of the Celebrezze Zangy Community Legal Education Project.